Hello everyone, my name is Vineeth and this is my very first association with the Virtualaw Academy and this is my very first video as well. So please let me know the feedback of my work through comment. That would be very helpful to me. And before starting off anything, I would like to urge everyone to take care of themselves during the present pandemic because you never know what's in store and you never know when these exams are conducted and everything, but till then please take care of yourself in the present scenario. And to moving on, uh, this particular session is all about the approach of how to solve the legal reasoning questions in the changed pattern of CLAT 2020. uh, Firstly, before going to CLAT itself, I'd like to speak for a couple of minutes about the competitive exams and how they has to be approached, how they have to be approached. See, firstly, whenever there is any change in pattern, just like there is a change in pattern in the legal reasoning in of for the CLAT, whenever there is any change in pattern of a particular section or anything, don't panic. There is absolutely no need to panic. In fact, it is good because no one is going to have an undue advantage because he or she is preparing for the same since past few years. Everyone will be on the same footing when a new pattern comes into picture. So there's absolutely no need to worry, and this is in fact very good. Whenever there is any change in pattern, it's good that it's good if you're giving your first attempt. And how and if you go with the stats, it's always the fresh people are more than the repeat repeat people. So it's actually more good than bad. And secondly, for any competitive examination, the important thing is there are two important things, that is time management and the strategy. And coming to the time management, almost every coaching center and everyone, they reiterate the importance of the time management, and I say the same. Time management is very important and it's very difficult to master it. It can only be done if you if you practice and practice, and there is no alternative to it. There is no alternative to time management, how to master it. So give as many mocks as possible, and try to know where you are strong at and try to know where you are weak at by managing the time, that and then allot the time accordingly. Uh, so it actually varies from person to person, so it's totally upon the student to master the time management, and that could only be done through practicing mock. So please practice as many as possible. And the other one is the strategy. And coming to the competitive exams, they are always about playing to your strengths. uh, Always focus on your strengths. I repeat it, always focus on your strengths, which many people tend to ignore. That they focus more upon the sections where they are weak, where they are weak, and try to overcome their weakness, but they tend to ignore the easy marks. Wherever you're strong, if you're strong in a particular section, those are your easy marks. Don't afford to lose your easy marks. And because the competitive exams are always about scoring marks and scoring high marks, so whenever there are any easy marks available, don't afford to lose them in competitive exams, because they help you in scoring high, so that you can get a better rank. So don't afford to lose the easy marks. And I don't intend to say that you completely neglect the weakness, but try to score the maximum number possible in the areas you're strong at. Please don't ignore this side of the coin. And this particular session is all about the legal section, and here I have tried to explain you through a sample question and through a sample question. And the role of English in the present legal aptitude pattern has significantly increased because of the passage type of questions. And passage kind of questions are also kind of time killing, and therefore the importance of time has also increased through the present changing pattern for the legal aptitude. uh, Personally, I don't like the present pattern of testing legal aptitude because it has become kind of comprehensive passages under English rather than legal aptitude. This is my personal opinion, but again, it's a waste of time to discuss about it, as the pattern is already fixed. So moving on to the question. Oh, I have selected Major Port Authorities Bill because it is very recent in news, and please kindly go through the recent bills or acts through the uh, bills or acts in the last 1 year, so that you'll get an idea of them, and more likely all the recent acts and bills in the past 1 year, they'll find a place in the examination. And moving on to the present question, Major Port Authorities Bill 2020. The Union government moved the Major Port Authorities Bill 2020 in the Lok Sabha on March 12, 2020, to convert the 11 major port trusts into port authorities. This bill is a compromise plan after the worker unions opposed the conversion of ports into companies. Compared to the Major Port Trusts Act, the 1963, the bill reduces the number of sections to 76 from 134 by eliminating overlapping and obsolete sections. It simplified the composition of the Board of Port Authority, which will now comprise of 11 to 13 members from the present 17 to 19, which shall now comprise of the representatives of the state in which the port is situated, Ministries of Railways, Ministry of Defence and Custom, Department of Revenue as boards in the Board of Port Authority, apart from the government nominee member and a member representing the employees of the Major Port Authority. The heart of the bill is the Major Port Authority, which will have powers to fix the reference tariffs for various port services, which was earlier fixed by the Tariff Authority for Major Port Stamp. For the purpose of bidding for PPP, public-private partnership projects, it has been delegated full powers to enter into contracts, planning and development, fixing of tariffs, except in national interest, security, and emergency arising out of inaction and default. The board of each major port shall be entitled to create a specific master plan in respect of any development or infrastructure established or proposed to be established within the port limits and the land appurtenant thereto, and such master plan shall be independent of any local or state government regulations of any authority whatsoever. However, to review the decisions of the port authority, the bill proposed the creation of an adjudicatory board at the bill adopts a landlord port model where the publicly governed port authority acts as the regulatory body and the and as a landlord, while the private companies carry out the port operations, mainly cargo handling activities. Here, the port authority maintains ownership of the port, while the infrastructure is leased to the private firms that provide and maintain their own superstructure and install own equipment to handle cargo. In return, the landlord port, that is the owner, gets a share of the revenue from the private entity. The role of the landlord port authority would be to carry out all the private sector services and operations such as award of bids for the cargo terminals and dredging. Weeks after tabling the bill on the floor of Parliament, the fear gloomed among all the stakeholders involved regarding the power of issuing directions to the Port of Authority given to the central government. The privatization behavior displayed by the government of the past couple of years just added fuel to the fire. The Parliamentary Standing Committee insisted that it is upon the government to uplift the confidence of the stakeholders involved, and it should strictly ensure the managerial and financial control of the port remain with the board. Government in its defense stated that there is nothing new about this particular provision, as this is similar to the section 111 of the previous act, and the board will be given enough opportunity to express their views before issuance of any kind of directions. It is much welcome because the port is a national property and the privatization of it would only hamper the public interest. So moving on to the questions. The first question is, what is the rationale behind representation given to various departments in the Board of Port Authority? Option 1, because they were given in the previous act. Option number 2, so that every department has control over the private investors in the port. Option number 3, Board of Port Authority consists all the relevant stakeholders of Port Authority for better adjudication. Option 4, so that it does not go against the constitutional principles. If you look at the question again, rationale behind representation given to various departments in the board of port authority. What was the composition of board of port authority? The composition of board of port authority is given in the paragraph number 1, which talks about various state heads given representation, and the Ministry of Defense and Ministry of Railways, who are those who are given representation in the board of port. If you look at it, we can look at the composition of the board of authority. So looking at that, we never know how it was in the previous act on the particular section. So option number 1 could be ruled out, because from the passage we cannot infer that uh, particular heads were given representation in the previous act too. So option number 1 is ruled out. Option number 2, so that every department has control over private investors in the port. Okay, moving on to option number 3. Board of Port Authority consists of all relevant stakeholders of Port Authority for better adjudication. So if you look at it, all the relevant stakeholders, look at the composition again here for the question number 3. That is, the ministry of the state is given representation where the particular port is located. The Ministry of Railways is given is given is given a place for the representation, because it helps in transportation of the port activities, and Ministry of Defense is given representation in the particular board of port authority, which has its say because ports are always of national importance. So this particular section seems relevant. Like this particular option says that board of port authority consists of all relevant stakeholders of port authority for better adjudication. So keep it aside. Moving on to the fourth option, that is, so that it does not go against the constitutional principles. Okay. Among all the four options, which whenever the four options were given in the examination, there might not be any particular pinpoint correct answer at sometimes. So you have to choose what is the best answer among the given four options. If you look at the current four options, the more relevant option to the present question is option number 3, because all the relevant stakeholders are being given a representation in the board of port authority, which is more likely then second option, that is every department has control over the private investors of the port, because it's not that every department has control over the private investors in the port. It is the board of port authority that has control over the private investors in the port, not the departments of the state. So option 2 can be relevant, and so option 3 is more relevant option among all the four and the best of the four. So option 3 will be the answer. And coming to the fourth option, if you study it, it's written that does not go against the constitutional principles. Generally, they tend to confuse the students with the fancier terms in English or in the law, just to confuse you. Don't go by that flow. That if you don't know anything, just don't mark it. If it is silent about it, just don't mark it. Always mark an answer when you are 100% sure about it. Uh, don't go with the flow of the fancy words of law. So the option for this question would be uh, option number 3, that is board of port authority consists of all relevant stakeholders of port authority for better adjudication. Number 2, which of the following is true regarding the landlord port model? Option A, operation of private players on a government owned property. Option B, because the board gets share in profit of the private investor. Option number C, power to adjudicate remains with the board of port authority. Option number D, all of the above are correct. Option number E, A and B are correct. So there is an exclusive point in the passage which deals about the landlord port model. So go back to that and look at it again, read it again before solving this particular question. And the options are, well, okay, well, let's go for the options again. Option A is operation of private players on the government owned property, which is true in the landlord port authority, because the board of port authority acts as the owner, and the uh, private investors operate on that particular land by taking lease or something. So option A is correct. Option B, because the board gets share in profits of the private investors, which is also true and which is also been mentioned in the particular passage, that the board of port authority gets a share in the profits of the investor. Option number C, power to adjudicate remains with the board of port authority. This is wrong. The power to adjudicate remains with the board, adjudication board at apex level, and it is not with the board of port authority. So option number C is wrong. So that makes option number D all of correct. That is wrong. So option E, A and B both are correct. Option E is the right answer. So here, what I have to remember is why I have framed the options in such a way for this particular question is, uh, whenever the natural tendency of the students uh, goes whenever they see it an easy question, they tend to they tend to overlook it. Here the power to adjudicate remains with the board of port authority is given just for that purpose, but because whenever you read it in a very speedy manner, which happens usually in the examinations, you generally presume that that one is also right too in this particular passage. But the power to adjudicate remains with the adjudicatory board at apex level and not with the board of port authority, though it has managerial and financial control over the private investors. So read the options carefully before answering them, and then answer it. Question number 3, what is the reason behind retaining uh, of certain sections from the previous act? Option A, same analogy of deleting the obsolete and overlapping section is followed here too. The parliament won't be willing. Option number B, the parliament won't be willing to change certain provisions which are in existence for very long. Option C, since 1963 these provisions proved to be successful. And option D, none of these. So same as I said in the previous question, that is the correct option would be the uh, what is the best among the given four options. Here if you look at the options once again, all the options are kind of more or less similar, but looking at the options, the option A is best among all the other options, which is because the same analogy of deleting the obsolete and overlapping sections is followed here too. If there is any overlapping section, you tend to delete it, but by doing that you retain one section. When you delete an overlapping section, you retain one section. So the same analogy has been implemented here. So if then and option B doesn't totally make sense, because the parliament won't be willing to change certain provisions which are in existence for very long, and even though they are in existence for very long, if the parliament feel that they have become obsolete now, they can change it. They can make a change. So giving being in time for so long doesn't give them guaranteed that it should be retained. And option number C is since 1963 these provisions proved to be successful, and this could be one good point. But among A and C, if you compare, option A is more relevant than C. So our answer would be A. Coming to question number 4, does the amended Act of Major Port Act ensure the concept of privatization? This is very important questions. Moving to the options, yes, because the private players have been given more liberty than before. Option number B, no, because the objective of the act is to curb privatization by giving managerial powers to the board of port authority. Option C, no, because who should who should be the private investors still decided by the port authority, as the entire decision making is with the port authority. Option D, both B and C. So if you look at the particular section, per particular question. So if you look at the options here, whether they ensure the concept of privatization is the first question. Yes or no? Yes or no? There you go. There you see, and then yes or no. After that, you'll see the reason for that yes or no. So that is how it works. Whenever these kind of questions are being asked here, whether the amended Act of Major Port Acts ensures the concept of privatization, it is yes, it ensures the concept of privatization because the private players have been given more liberty than before. This is the right answer. I'll tell you why. Here, the present act ensures the concept of privatization, but not completely. That is what intended. If you go by option B and option C, they seem right too. By saying that because the objective of the act is to curb the privatization by giving managerial powers to the board of port authority. See, this is not the objective of the act. The objective of the act is to ensure the private players a free zone and free to act on their own and give the profit share to the board of port authority. And since they're giving the land lease the leased land to the leased land to the private players, they obviously need to have the managerial powers to control them. So that is the reason that they have the managerial powers for the better administration, but not to curb privatization. So option B is ruled out. Coming to the option C, no, because it should be the private investor. Who should be the private investor is still decided by the port authority. Yeah, who should be the private investor is still decided by the port of authority, but it's not an arbitrary decision. The decision of who to be the private investor is always according to the rules framed up. They go by the tenders, which is a legally which is another legal process which has to be which has to be done. So who comes better, which private player is better among them, then they'll be given an opportunity or a chance to conduct the port activities, but not arbitrarily on the decision of port authority the private investor selected. So option C is also wrong. So that leaves us with option A only, and option A is the right one. And that is why I have also framed the options in a particular manner that if you see both B and C are right, that is the reason why they have kept an extra option. Don't go by that logic, which many people tend to go by that logic. Please don't uh, go by that logic that since no is right answer and both the reasons are right, that is the reason they kept another option that both B and C are right. No, that it never competitive exams never function that way. Question number 5. Master plan will be drafted by the Board of Port Authority under the bill violates the constitutional principles by discarding the state laws. There's a mention of the master plan in the passage. Yes, right. What does it say? That the Board of Port Authority has the right to make laws, and any authority whatsoever from the state or center, they don't have an authority over the particular area, and the master plan is what that supersedes all the other existing uh, laws. So whether that is uh, constitutional or not, because that particular provisions they disregard the state laws, so that is against the principles of constitution or not, is this question. So the options are option A, no, because the major ports come under the union list, the center can make laws. Option B, yes, so that goes against the law of the land of the respective states. Option C, yes, state 2 has powers under the concurrent list and they can't be totally taken away. Option D, no, because in the concurrent list, center made laws prevails over the state laws. If you look at the options right now, this I kept this question deliberately here because even though they said in the question that the particular section requires no prior legal knowledge, a prior legal knowledge can actually help uh, in some questions. You can directly answer them. uh, that and so please make sure that you have that if because they had been mentioned that there is no prior legal knowledge required or prior knowledge regarding to the law is not required. Even though learn few important theories, so that it don't look alien to you in the examination, and you can solve purely some questions based on the knowledge you have, on the legal knowledge you have. For that purpose I have imbibed this section, and the answer to this particular question is you can only answer to this particular question when you know about the union list, concurrent list, and the state list. Only then you can answer it. So that is the reason why I have kept this question, so that you read laws. If you come across a particular passage, please kindly read in brief about that particular law, what it intends and why it intends, before only being strictly uh, uh, being limited yourself to the passage. Go beyond that and do some research. That is what I intended to say. So here the option is option A, because all the major ports, they come exclusively under the union list. They are not in the concurrent list. The major ports are center has the complete authority, and they have the complete authority. So under that power given to the parliament, they have enacted this particular act. And so option A is correct, that is major ports come under the union list, so center can make laws. And this is an exception given in our constitution, and whenever there's any conflict between center and state, you know that center prevails, but those are restricted to the laws which are in concurrent list. So if there is any subject in the concurrent list, if there are two laws, the central made law prevails over the state law. But here, as a matter of fact, the major courts come under the ambit of the uh, union list of the constitution. So option A is right, and you can actually derive it. You need not remember all the lists, union list, state list, or central list. But if when you read about the act in particular, when you read about the major port bills act, it says that it's extended to all the major ports in India. So that itself says that, and it also talks about the parliament enacting the law, which says that that particular ports come under the ambit of the central government. So that is the reason why I put this one, so that you need to have the basic knowledge of what these acts are generally about. Even though this strictly said it's not required, it might come in handy in certain situations. I hope you find this video helpful, and if you have any doubts, please ask in the comments, and uh, please kindly give your feedback for this particular session. Thank you, and all the very best for the examination too.